The ATF has been temporarily blocked from enforcing their latest infringement on your right to bear arms. So the future's not looking too bright for the ATF and their new engaged in the business rule that seeks to make anyone who sells a gun a firearms dealer. Be sure to stick around to find out what happened in this case and most importantly, who is going to be protected by this order. Hello everyone and welcome to the Firearm Firm channel. I'm attorney James Phillips, a former prosecutor and founding partner of Katz & Phillips PA, also known as the Firearm Firm. Today we are discussing a favorable order that was released this past Tuesday night, June the 11th of 2024, out of the Northern District of Texas in the case of Texas et al. Versus ATF all. I previously did a video discussing this case a couple of weeks ago, and if you have not seen it, you can click on the link above or the link down below in the description section to catch up on speed. So the plaintiffs in this case consist of the states of Texas, Mississippi, Louisiana, and Utah, along with the Gun Owners of America, Gun Owners Foundation, the Tennessee Firearms Association, the Virginia Citizens Defense League, and a named individual plaintiff, Jeffrey Tomey. All of the plaintiffs except the states of Mississippi, Louisiana, and Utah had previously obtained a preliminary injunction / temporary restraining order preventing ATF from enforcing their engaged in the business rule, but it was set to expire on June the 2nd of 2024. Now the reason Mississippi, Louisiana, and Utah were not part of that order is because at the time the court determined that they had failed to show standing. Before we dive into this order that was issued this past Tuesday night, be sure to take a second to show your disgust with the ATF by hitting that like button. And if you haven't already done so, please take another second to hit the subscribe icon located down in the bottom right hand corner of this video to subscribe to the Firearm Firm channel. So this order found that all of the plaintiffs, including the 3 that were left out of the first temporary restraining order, had standing to bring this lawsuit. Now, I'm not going to get into the whole standing arguments made by the defendants and the court's analysis of why, in fact, the plaintiffs all have standing to bring this lawsuit and this motion. But for any of you that want to read about that, I will attach a link to the order down below so you can knock yourself out. For those of you who are joining us for the first time, in order for a plaintiff to obtain a temporary injunction or temporary restraining order, they must show 4 things which are all posted on the screen. Now, for those that routinely watch our video, you already know that the first one is probably the most important of the 4 factors. So let's go ahead and take a moment and dive into the court's finding. The court determined that the plaintiffs are substantially likely to prevail on their APA claim, which is the Administrative Procedures Act, because the final rule is not consistent with the Bipartisan Safer Communities Act. The court wrote, "The final rule clashes with the text of the BSCA in at least 3 ways. First, it asserts that there is no minimum number of firearms to actually be sold to be engaged in the business for the purposes of licensing requirement. A single firearm transaction or even a mere offer to engage in a transaction may suffice, but the BSCA says otherwise. The term engaged in the business means, as applied to a dealer in firearms as defined in section 921 subsection A11A, a person who devotes time, attention, and labor to dealing in firearms as a regular course of trade or business to predominantly earn a profit through the repetitive purchase and resale of firearms. But such terms shall not include a person who makes occasional sales, exchanges, or purchases of firearms for the enhancement of a personal collection or for a hobby, or who sells all or part of his personal collection of firearms." Second, the final rule suggests that actual profit is not a requirement of the statute. It is only the predominant intent to earn a profit through the repetitive purchase and resale of firearms that is required. In other words, a person may repeatedly advertise and display firearms for sale and therefore demonstrate a predominant intent to earn a profit from repeatedly reselling the firearms purchased, but never actually find a buyer. But section A22 of the BSCA provides the term to predominantly earn a profit means that the intent underlying the sale or disposition of firearms is predominantly one of obtaining pecuniary gain, as opposed to other intents such as improving or liquidating a personal firearms collection, provided that proof of profit shall not be required as to a person who engages in the regular and repetitive purchase and disposition of firearms for criminal purposes or terrorism. Third, the final rule arbitrarily eviscerates Section 921, subsection A21C's safe harbor provision. That provision reads, the term engaged in the business shall not include a person who makes occasional sales, exchanges, or purchases of firearms for the enhancement of a personal collection or for a hobby, or who sells all or part of his personal collection of firearms. Nothing in the foregoing text suggests that the term personal collection does not include firearms accumulated primarily for personal protection. Yet, that is exactly what the final rule asserts. Lastly, the final rule creates a set of presumptions indicating 1, when a person has the intent to predominantly earn a profit, and number 2, when someone is engaged in the business. But these presumptions are highly problematic for at least 2 reasons. First, they flip the statute on its head by requiring the firearm owners prove innocence rather than the government prove guilt. The presumptions are rebuttable, so in the event a civil or administrative proceeding is brought and a presumption is raised, it can be rebutted with reliable evidence to the contrary. Second, several presumptions conflict with the statutory text. Now, because the court found that the plaintiffs were likely to succeed on their merits of their APA claim only, the court didn't bother addressing any of the other claims made in the plaintiff's complaint. As to the remaining 3 factors needed to issue a temporary restraining order or a temporary injunction, the court found that the plaintiffs would suffer irreparable injury if the injunction was not granted, and there is generally no public interest in the perpetuation of an unlawful agency action. Finally, the court found that both the balance of equities and the public interest weigh in favor of allowing orderly judicial review of the rule before anyone shuts down their business or gets sent to jail. So, does this temporary injunction that was issued in this case protect everyone out there? The answer is no. The court specifically said it protects all plaintiffs pending the resolution of this lawsuit. So what does that mean? If you live in Texas, Mississippi, Louisiana, and Utah, you're protected by this order. You are also protected if you are a member of Gun Owners of America, Gun Owners Foundation, the Tennessee Firearms Association, or the Virginia Citizens Defense League, and that is regardless of where you reside. Now, we'll keep a watch on this case along with the other 2 cases fighting against ATF's latest attempt to infringe on your right where they're engaged in the business rule. But in the meantime, if you have any questions about this video or questions about the Second Amendment or your right to defend yourself and loved ones, be sure to leave those questions down in the comments section and we'll respond. Until next time, stay armed and educated.